Okay, so I can see us on YouTube.
Amazing.
Yeah.
Fantastic.
Oh, technology does. We are all going to be YouTube stars.
There you go. I'm already a YouTube star. There's a thing called Moscow Lawyers. You can watch an hour and 15-minute interview of my life.
Okay.
If you have nothing better to do.
Well done.
The only bit that I don't see of whether people are watching us or not. Good afternoon, everyone. We're going to start the seminar in a couple of minutes, just giving everyone an opportunity to join us. So we will start in a couple of minutes. Hi to all of those joining us. We're just giving it a couple of minutes to let people join the webinar, and we'll be starting in probably in about a minute's time. But thank you to all of those that have joined already. And I see that we've got people joining us because we've already got comments coming in on the YouTube channel. So that's good. And it's not just my mum. Hi, mum. We've got viewers from Minsk. We've got viewers from Ukraine.
Artem, I hope from Poland as well.
No, I'm sure we will do. So far, they haven't said they're from Poland if they're from Poland, but I'm sure they'll let us know. Right, I think it's 3 minutes past 3 in London. It's 3 minutes past 5 in Kiev. So I suggest that we will start today's webinar. Thank you to everyone who has joined. This is the first webinar being organized by the Ukrainian Arbitration Association, which is an organization that promotes links in the arbitration community between practitioners, academics, and arbitrators who are interested and work internationally, and in particular with Ukraine. We are expecting a good turnout of attendees to this very first webinar, and this is intended to be a first of a whole series of webinars. So if any of the viewers have any suggestions or feedback, do send those in. Today's topic for today's webinar is guerrilla tactics in online hearings, and we will discuss that over the next hour or so. I'm very honored to be moderating today's webinar, and we've got 3 amazing speakers with a wealth of experience and a whole number of perspectives. We have Olga Hamama, we have Maria Hauser-Morel, and we have Benjamin Sino. So thank you, all of you, for finding time to both prepare for today's webinar and for joining me today. So we're going to start with a short warm-up, and the idea is to, as the world is clearly going through the pandemic, an arbitration world is also coping with the times, and this has resulted in a greater number of online hearings taking place so that arbitration disputes continue to be resolved. And today's discussion is going to be about the fact that sometimes, even though the hearings are taking place online, there are still opportunities for certain guerrilla tactics, and we are going to talk as to what issues these cause and how to deal with them. So I think I'm going to go around our speakers and ask them to begin with to share with us their latest experience of taking part in online seminars. I'll ask them to say whether they've done this, in what capacity they've done it, what went well, and what was the biggest challenges that they saw. So let's start with Maria. Maria, what's your experience of online seminars? Hello.
Thank you very much, Artem, and welcome everybody. I've just returned after many, many years at the ICC to private practice to Hannefeld. And so I've only started in February and have not in person attended any online hearing. If you just allow me, throughout the years at the ICC, we've seen hearings being conducted online, usually in part. And definitely this has not been something shocking. And usually parties were very happy to just advance like this. So it's not a novelty. And I've seen it done also in Central Eastern Europe.
Great. Thanks, Maria. Olga, what's been your experience today of online hearings?
Thank you very much, Artem, and thank you very much for the invitation to discuss this topic. So personally, I have not participated in a complete virtual hearing yet. However, in terms of partial virtual presence, be it for witness examination or expert examination, my first experience goes back to the year 2012. And back then, actually, it was like literally the first project I was dealing with this question. I was secretary to the tribunal back then, and we were faced with the fact that witness could not fly in for valid reasons. And I remember it was a Skype call back then, and I think that some of the panel members never used Skype before. But it went very well. And since then, you know, there were many hearings. There were sometimes technical disruptions because of bad connection, but this topic was discussed before with the parties. So one would either dial in again or, you know, postpone the witness questioning. So that didn't appear to be a problem. What's happening right now in the cases I'm participating in is that we notice that, for example, case management conferences are now by rule conducted by terms of video conferences rather phone calls, which was still predominant in recent years. So yes, those are like the very first effects of our experience in the recent weeks. And I do have to deal with the issue now of potentially ordering an online hearing despite a rejection of a party.
Well, we'll come on to that. That's an interesting particular problem that we will discuss how best to address it. Benjamin, what's been your experience to date?
So a hearing we've had in the past 2 months is a number of hearings that took place virtually, but all these hearings had the specificities of having only pleadings, no cross-examination. So it was either emergency arbitrator or closing statements or opening statements and rebuttal. And I think at the time, because it was exactly at the time of the outbreak of COVID-19, the challenge was ensuring communication between teams in the course of the hearing, because teams were located in different places, and that went pretty well with usual chat, WhatsApp, and other devices. Other challenges were getting documents to the arbitral tribunal when the mail service was not functioning properly, and again, that was solved in an efficient manner by electronic hearing bundles. So I think that a number of these challenges were very specific to the context. I think that it's another challenges that we've had, which were used by arbitral tribunal to postpone hearings, were of course lockdowns, witnesses not being available, technology disruption of hearing preparation. I think a number of these challenges may evolve now because we can see the situation being clarified and being a restriction being lifted. And I'm actually preparing 2 different hearings right now, virtual hearings, where we have other types of challenges such as time differences and other. But to be fair, for the experience we've had internally at Sherman, we've had very good, efficient hearings But again, it was because I think one of the reasons was no cross-examination, which simplifies the process.
Yes, no, I would have to agree with that. I had a hearing actually before sort of COVID-19 where I was chairman of the tribunal, and it was a relatively small dispute between a Russian and a Kazakh party. And we had a Russian arbitrator in Moscow, a Kazakh arbitrator in Nur-Sultan, and myself in London. And one of the parties was in Moscow and the other one was in Nur-Sultan. And we had a three-way Skype hearing. And because there was no witnesses but submissions, it actually worked really well and probably was the most efficient way for a small dispute. So we'll also maybe have a discussion as to what cases we see online hearings continuing, perhaps even post COVID-19, because there are clear, in some instances, some clear advantages. I think now that we've all warmed up and we've got a good number of guests listening in, we've got Cyprus, Paris, London, Kiev, Serbia, Switzerland, Egypt, Minsk. So half the world is pretty much with us. So hi everyone, and thanks for joining. So we're now going to have a discussion of some of the key themes to do with guerrilla tactics in online hearings. And we're going to spend about 10 minutes on each of the themes. One of the speakers is going to introduce the particular topic, and then we're going to hear views from the other speakers on that particular topic before moving on. And just to let our guests and listeners know that if you send in your questions via questions on YouTube, we should hopefully have some time at the end of the webinar to go through those and to try to answer at least some of those. So do send your questions in through the chat feature in YouTube. So then in terms of the first theme that we'd like to discuss is the setting up and the preparation for the hearing itself. Obviously, the parties and the tribunal need to agree to an online hearing. There's different mechanics, different preconditions that need to be discussed. There's questions of security and cybersecurity, how will the hearing work, etc. And Maria, if you can please kind of give us an introduction to this theme and some of the issues for us to consider and discuss.
Thank you very much. And so we are to discuss this in the context of guerrilla tactics specifically. And so as you can all imagine, because there will be more and more online hearings, they will become more common, they will likely trigger more and more objections and some new models of guerrilla tactics. We will discuss this. So they are possible guerrilla tactics in an online hearing like in any other hearing. But I think we should first clarify that not every objection or protest should be conceived as a guerrilla tactic. Something that may appear from one perspective as a guerrilla tactic is in fact a result of a genuine concern or even misunderstanding. And I think that with respect to these online hearings, where some of the users may not be very used to this new form, they may simply misunderstand some certain things and try to protest because they just don't get it. And I think that the tribunals should be mindful of this aspect of online hearings. Let me just say that since the pandemic, of course, we've seen many protocols, guidelines, and checklists on online hearings, and we don't have time to list it, but I refer you to a very helpful list of these resources that was compiled by Arbitration Center Delos, where you can find a very long list of that. And I would particularly draw your attention to the very helpful guidance note prepared by the ICC related to COVID. So the first question, as you said, Atem, is whether to go online fully, in part, or whether it's necessary to postpone the hearing. And I would just like to say that this question should be raised as soon as possible. Parties and tribunals should not wait until 2 weeks before the due date to raise the question, oops, what are we going to do? And as many of the commentators have raised recently, this should not be an automatic decision to go online. The decision whether in a particular case you can go online will depend on various elements, such as the the nature of the hearing, whether it's on liability, quantum, or something else, the number of witnesses, the length, the complexity of the case, the issues to be decided, and as well urgency in completing the proceedings, whether there's a particular urgency. And now, regardless of whether the hearing is in person or online, there may be surprises, and we all know them: late submission of documents, a witness suddenly announcing that he's unavailable to attend in person, and so forth. And some of these behaviors are unethical guerrilla tactics, and including now the ones that will become possible when technology is involved. And so we would expect tribunals, as always, to try to anticipate, minimize such surprises by creating, after having heard the parties, clear rules for online hearing. And I wish to address just 3 points here. First, so the tribunal should discuss procedural rules for the hearing. And here, in addition to the usual rules for the hearing that we normally find in traditional procedure order number 1, now the tribunal should address issues specific to online hearings, which you have raised at them, such as verification of presence, online etiquette, cybersecurity, online document bundle, display options, and things like this. I would suggest that in new cases that start right now, this should be already addressed at the first case management conference to try to get an agreement as soon as possible. And I've just seen a very recent article published by Maxi Scherer in Kluwer, and she suggests considering possibility of having an online hearing already when now entering into arbitration agreements.
Mm-hmm.
So that's also something that parties may consider, whether to specifically allow this option. When preparing the online hearing, in addition to discussing procedural rules for the hearing with the parties, the tribunal should, in my view, specifically address all these technicalities, all these technical issues, such as which platform to use, the minimum technical requirements, so that everybody, it's essential that everybody understands how the process will look like and will have trust in the process. Because again, oftentimes, some of the guerrilla tactics are a result from misunderstanding and lack of trust. And so I could imagine many of these tactics being applied here because party doesn't understand. And by discussing these things up front, the tribunal can limit risk of such guerrilla tactics. For instance, limit the risk of a party saying on the morning of the hearing that the connection is not working and they cannot participate in the hearing. And the third point regarding the preparation of the hearing, as it is usually done, the agreed rules for the conduct of the hearing should be recorded in writing. It's an agreement on a procedure, and we know very well, we will discuss later, that it's very important that for the enforceability of the award to have a clear view on what was agreed. And to conclude, I would say that when faced with guerrilla tactics in pre-hearing phase or during the online hearing, tribunal should always afford each party opportunity to comment, but should not fall into due process paranoia. But I suggest that we can discuss it. That would be my conclusion.
That could be a whole separate webinar on that, Maria. So, yeah.
Yes.
Maybe we'll do one later. No, thank you. Benjamin, a question to you. I think something that Maria started with saying that an online hearing should not be an automatic kind of decision, but there should be various factors. I'm going to be controversial. I would say right now, it seems to me that it is the only answer. I mean, there's so many difficulties and problems, particularly in international disputes, of actually having a physical meeting for a hearing, that it seems that by comparison, online hearings are the answer to all those problems. Do you think there's any situations for which online hearings are not a suitable option?
Yes, definitely. To be fair, I think we need to have a very open view of this, and we can have a dogmatic view. I know some arbitrators don't like virtual hearings. Some prefer hearings in person. I don't think that we can keep doing that, and we need to have an open mind. That being said, I personally believe that virtual hearings are not suited for all types of cases. And for a lot of cases, whether procedural hearing, pleadings, closing statements, opening statements, hearings of 2-3 days, even 5 days, with a very limited number of experts or witness, cases which are not fact sensitive or fact intensive, that is, I think personally, that can be suited. There's a lot of potential difficulties, but they can be solved. I think it's a different context when you have a 3 or 4 weeks hearing, experts and witnesses in 5 different locations, time differences, which are maybe more than 6 to 8 hours. All of that needs to be factored in. And cases where you have a lot of witnesses and experts who have submitted very lengthy experts report or witness statements on very specific issues such as, I don't know, bribery, fraud, corruption, all of these issues, I think that a decision to do a virtual hearing in that specific situation needs to be taken very carefully, because again, it could go against the interest of a party who really needs to take time with the witnesses and certain conditions to do that. So I think that, again, I think we all agree that virtual hearings is very adapted for some kinds of hearings. I think we need to look at every circumstances of each case, and although we want to have an open vision, some cases may not, even in the current situation, which may imply delaying, some specific cases may not justify a virtual hearing, at least not a full virtual hearing.
Thank you. And Olga, a question to you on something else that Maria said. It's so in some circumstances there could be a guerrilla tactic. In some circumstances there could be a cultural misunderstanding, I think, as Maria said. How do we tell what's happening in a particular instance, and what's the solution with identifying which of those 2 options it is, and how do we address that particular problem?
Yeah, I do. You know, it is a very fair point, and one which we already experience in the analog world of arbitration. And I do think that specifically in the current situations, before we have some learnings, because each and every one of us has conducted a great number of virtual hearing, and then we could see specific patterns which would allow us, for example, to predict maybe certain circumstances, or already see how cultural differences can lead to such situation. The only key, from my perspective, at the end is really transparent and lean procedure, dialogue with the parties upon initiative of the arbitral tribunal in the first place. I'm sure that it would be also in the interest of many parties, but talking to the parties, discussing the procedure, discussing potential pitfalls which parties might face during that process, and referring to the existing rules, be it either IBA rules on parties' representation. So it depends, right, on the procedural regulations, also ethical rules, which are applicable to different type of legal representatives, depending on which jurisdictions they come from. So those are tools which I would think of in these proceedings. And I do think 1 year from now, we will have another type of dialogue. We all would have gained more experience in really conducting complete virtual hearings, because while I completely agree that it's a balancing act and we cannot say that each hearing is the same, I do think that the longer it takes to tackle the pandemic, to tackle the problem, we would see more and more virtual hearing happening.
Yeah. Thanks,
Can I just jump in with 50
Yeah, of course, yes. Go on.
Something interesting that ICC recommends in the ICC guiding note is to consider bifurcation. And so to think about bifurcating the proceedings, to decide through an online remote hearing issues where you don't have witnesses, for instance, and then allow the parties to settle the case, for instance. So bifurcation is an option as well today to advance the case without blocking it.
Yeah, that's true.
That's a really good point, Maria. And I was actually going to come back to you on a particular issue. One of the known advantages of arbitration is confidentiality. In the virtual world, we face additional questions of cybersecurity. how do you think that affects in the issue of having online hearings? Do you see it as a major problem, or as something that simply can be resolved through use of appropriate technology?
Well, first, we know very well from GAR that not all arbitration users are so concerned about confidentiality. But I think that today there are many means, very professional platforms that can be all, used that guarantee confidentiality. That comes with a cost, of course. So I might see a problem not for big users who have, can spend money, but there may be users who just don't have that much resources and who will not be able to pay that much for that. But then I'm not sure if anybody would be interested in hacking, an arbitration hearing for 20,000 euros. So
yeah, great.
On this, Artem, just to say, I think that about cybersecurity, the truth is that we will always have these issues, and often it's not so much the platform, which can be very secure, is the way that people use the platform. And you send passwords through Yahoo, through Hotmails. These are we know that these are easily cracked, and so it's always easily. So the problem is not the platform, which may not be secure. It may be just the computer of an individual, an arbitrator, a counsel, or someone else. So I think that concern of cybersecurity should be concern of everyone, and everyone involved in the process should follow professional measures and not just rely on a platform which may work perfectly well, but as long as people are using it properly.
Yeah,
and I think tutorials may be necessary in some cases to alert people to that.
All really good points. I think let's move on to some of the specific issues, and I think the next theme that I think we should discuss is the participation of party representatives in online hearings and all the different issues and questions that this creates. Olga, can you introduce this particular theme to us?
Sure. Thank you, Artem. Again, I do think that at the moment we are facing an unprecedented situation, and many party representatives as well as arbitrators have very limited and maybe no experience at all when it comes to virtual hearings or virtual examination of witnesses or experts. We had this discussion going on now for a couple of weeks, right? And we see that there are some legislative gaps, or at least which provides for room for interpretation. This unique situation and this transfer might, of course, provide enough ground for guerrilla tactics in virtual hearings on behalf of legal representatives, or not on behalf of or by themselves. Speaking of different types of guerrilla tactics, I thought of three categories. So the first one is the one we already started talking about, and I'm sure it is going to be a difficult topic which will keep many of us busy, is the objection to holding an oral hearing by a party representative. While I do think that there are a lot of situations which might provide for solid background for such a rejection, still many rejections might come, first of all, maybe because legal representatives are not used to conducting virtual hearings and are, have some adverse experience or attitudes to using technology in general. It is also true, however, that we cannot, at least, for example, speaking of Germany, there is no case law now at the moment confirming that it is okay to order a virtual hearing by an arbitral tribunal despite a rejection. But there is also no case law suggesting that an arbitral tribunal doesn't have the power to do so. So these situations, I think, might be used by many legal representatives to disrupt hearings. So when objection comes without valid reasons, but simply, let's say, using this unique situation and maybe indeed existing legislative gaps. So then I think the second category would be guerrilla tactics, which would basically mimic guerrilla tactics, which we already know from the analog world of arbitration. And these, just to name a couple of examples. I mean, of course, we speak here about unfair obstruction of hearing, which might ultimately jeopardize enforceability of an arbitral award. So we might see legal counsel not showing up to the hearing. So that's already we experienced that in real, in analogous arbitration world already. It might also be an ambush presentation of new evidence or even new counsel. So if, for example, counsel appears during the hearing, which limits the opportunity of the arbitral tribunal and of the opposing party to do the background check to check whether this counsel fulfills all the neutrality requirements. Thinking of again proceedings as we know them, we might also see, for example, situations where witnesses out of sudden cannot participate in the hearing. Of course, again, might be for the same reasons as we've known them already, or for example, so that new facts or documents or new evidence are presented during the hearing. So transferring these tactics into digital world and thinking of a virtual hearing, first, of course, we might see some new tactics or new actions while transferring these tactics into digital world. So, the arguments might be different. So it might as well be inability to access secure internet connection, inability to access specific facilities, or to appear in specific facilities, for example, might be because of the current COVID restrictions, so even physical restrictions. If one would have to go to a hearing center or to a law firm, for example, to be able to participate in this hearing via more advanced technology than that we might have at home. Then I thought, and it's a bit of a daunting exercise in terms of I don't want to give any bad ideas to anyone, but it is a bit of a creative exercise thinking of what can actually happen, right? But necessary exercise as well, both being party representatives and members of the arbitral tribunal, thinking of what type of new disruptive tactics can we think of or we can predict when it comes to virtual hearings. So again, I think a lot of them are based on the technological access to technology or technology-based arguments like bad connection, disruption, inability to connect to a hearing, but also possible tactics, for example, to disrupt someone's presentation or to disrupt questioning of a witness. And, those arguments might be repeated, or arbitral tribunal might direct a witness to repeat an argument, but still maybe the overall impression and the possibility to fully and equally present a case by a party might be disrupted in that regard as well. We have already spoken about cybersecurity, and I would also like to address data protection in this context as well. I do agree completely that, we now see more and more recommendations coming up with regards to different type of technologies. Also, these platforms and technologies are becoming more and more sophisticated. But at the same time, let's face it, we've seen Zoom leakage hitting the news recently. Yesterday, there was in the news that, I think EasyJet, or one of the airlines, I think it was EasyJet, was a victim of a hacker attack, and millions of customer data was leaked. I do think that hacking into a virtual hearing might also impose danger of, revelation of business secrecy. Might also be, actually target the core benefit of arbitration, being confidentiality as well. And also might be a means of trying to, unduly influence witnesses, for example, as well. And it's not really a theoretical topic. Even I think back in 2015, there was a case, territorial dispute between Philippines and China, and there was evidence of hacker attacks on the Ministry of Justice and representatives of Philippines. And I do think, especially if you would think of investment arbitration proceedings, maybe even if we were talking about issues where states are involved, maybe issues of geopolitical importance. But even if we speak about business parties and commercial disputes, but in the age where data value surpassed value of natural resources, I do think that's something we should be very cautious about. And while systems are becoming better and secure, it doesn't matter to whom if you speak to IT persons, it's only a question of how much time someone would need to hack something, rather than whether it's possible it's at all.
Great.
So
Olga, if we can move on, sorry to interrupt, but we've got a number of questions to cover, but this is all really fascinating stuff. It seems with the hacking, it's probably most applicable where the stakes are high enough, as you say, for that to happen. But Benjamin, just wanted to ask you, in terms of party representative issues and guerrilla tactics, what are your views? Is that a kind of overhyped issue, or do you see real problems from that?
What I've been witnessing, because we've been talking about online, of course, virtual hearings, and a situation which may happen also is partially online virtual hearings, where a number of people can come at the hearing and others can't. And the fact that party representatives could not be allowed to attend in person the hearings. I've been witnessing a number of objections to virtual or partially virtual hearings by the fact that parties representatives could not attend in person. And that is an objection that is taken very seriously by arbitral tribunal, which I think is rightfully. But I think that having parties representative remotely participating by virtual hearing, as long as necessary measures are put in place, we know it's always more difficult when a party's representative is not sitting in the same location as its counsel. He may want to confer with his client. Of course, he can do that by using WhatsApp or whatever, but sometimes we can find that it would be more practical for the party's representative to be there, even more when it's state-owned entities or states representatives that actually opening a lot of pressure to be in person at the hearing. I think that in situations where the party's representative cannot attend in person, we should try to do it properly. The arbitral tribunal should be careful that each time a party wants to confer, a counsel wants to confer with the representatives of the party, he should be allowed to do so. But it's striking for me, at least, for parties' representative presence in person is something that came up in several occasions recently, whereas, to be fair, in a lot of arbitrations, we don't have the parties' representatives, and they often don't come, and it's just counsel there. So I was surprised to see this as an excuse or something used, at least to object to virtual hearing, or at least to partial virtual hearing. But I think that more and more going forward, we will have situations where parties' representatives will be allowed to participate virtually, even if there was to be a hearing to take place partially in person.
Great, thanks, Benjamin. Maria, just on what Benjamin and Olga have been saying, how important do you think parity and equality of parties on the issue of the way how parties are represented at a hearing is important? Is it necessary that everyone attends in exactly the same way, or one party could attend in person, another one virtually, and it doesn't really matter? What are your views on these types of discrepancies?
Being a real lawyer, I would say it depends. But I would just say that throughout the years of my work at the ICC, I would say that 15 years ago, when I started in 2007, it was quite rare that we would see party representatives directly attending the hearing, what Benjamin was saying. That's some tendency more in the recent years, and in a certain type of cases. Let's be frank. I mean, this usually applies to bigger cases, because in smaller cases, clients just rely on their lawyers and would not think about coming. Also, for cost purposes, they would just not have money to come to the hearing if already the lawyer is going there. And then, honestly, I mean, it's why if the participation in for whatever reason, if for technical reasons, for instance, the in-house counsel cannot participate, he or she could, for instance, just participate by telephone to hear to everything that is happening without, losing anything. So I think there are ways to go around it, and every time the tribunal should it's not the only. Again, the tribunal should not be bullied and should not just be afraid to take firm decisions, and always take them based on the whole context and the party's right to be heard and equal treatment, but within the scope of what's needed and possible.
Great, thanks, Maria. Well, we're more than halfway through our webinar. I think we've got just under 100 participants watching our discussion. And we've got people from as far away as New York and Nigeria. So we've got people from all over the world joining in. So we're looking forward to getting some interesting questions from our audience. So do send those in. And I think we'll move on to the next big theme. And this is probably something that's been briefly mentioned by most of the speakers already. And it's probably the most difficult issue to do with online hearings, and this is witnesses and the cross-examination and getting witness evidence. Benjamin, do you want to introduce this particular theme for our consideration?
Yes, thank you. So I think that again, we've discussed this, and we all agree that virtual hearing is appropriate for a number of hearings. And now the question is, how do you take into consideration cross-examination, witness evidence, and does it work efficiently? Can it work efficiently? And I think that, as I was mentioning before, I think a number of decisions to postpone hearings in March or in April, even nowadays, can be dependent on how do you tackle this problem. But just on a general background, I think we've all been used in the past of having cross-examination done remotely by video conference. I think the first time I did that was 7 years ago. It was a situation where one of the witnesses of my client couldn't come at the last minute, 2 weeks before the hearing. We had to find a solution, which was because it was our responsibility to make sure that the witness could properly be cross-examined. And so we made a reservation at a hearing center next to the witness home. We ensured that the counsel from the other party could attend the cross-examination, so be in the room with the witness. So we had a lot of things to be done. We did a lot of testing and worked very efficiently. Now, to be fair, I think a lot of lawyers don't like cross-examining a witness remotely. So of course, if it's your witness, you're happy because you feel that it's going to be more complicated for opposing counsel. But on the other way, it can be very testing, even more when there's translation issues, because you can have the situation of having not only to cross-examine a witness that is remotely, but including with a remote translation, which is something that is very well tackled nowadays by ICSID, for instance, by using Kudo, but still, it is more difficult for counsel. Now, with the COVID outbreak, I think a lot of arbitral tribunals were confronted with a very difficult situation. We want to continue the hearing. How do we do this? And they've made a number of choices. Some have said it's perfectly fine to do it by video conference. You can use a 360 video camera that shows that that there's no one in the room. Other people say, well, they don't have internet access. We don't have any situation that this happened in one of my cases. He's not a crucial witness. Let's do it by telephone. So that was at the time of the global outbreak of the lockdown. I think that nowadays, the main issues that often come up is, of course, ensuring that no one is coaching the witness or the expert. Is it credible? Does this has an impact on the credibility of the witness? Is it better to have him in person or by video conferencing? Does this have an impact on witness preparation? Because of course, lawyers cannot have in-person meetings with the lawyer. And lastly, and this is maybe one, which I believe is one of the most important, is the conduct of the way you have to conduct cross-examination. So my personal opinion is, if you can, if it's possible, you don't have your witness in an infected region where there's no possibility to reach him, I think we should try it as a priority to have someone in the room with the witness. I think that you can say you can see this from the camera, you can say that it's very easy to do the 360, but a lot of things can happen. The witness can suddenly have a problem with his computer. How do you make a difference between guerrilla tactics of shutting down your computer because you don't like the question and situations where there was an actual problem? So I think that as long as it's possible, having either parties representatives, but not only, you could have a third party bailiff, anyone, another lawyer being in the room and just ensuring that everything takes place in the proper manner, and potentially help the witness if he or she has a problem to use technology. The other problems are often raised, which I think are less problematic, at least from the perspective of arbitral tribunals, is the credibility. A lot of people will tell you, and a lot of arbitrators have been saying in the past 2 months, is that it doesn't change anything. As long as technology works, they can see the witness even better than in the hearing room. I don't really have an opinion on that. I still think that being in person is something important. But if you don't have this choice and look at the technology we're using, it works efficiently. Hearing preparation, we'll need to get used to not having in-person meetings with the witnesses or experts, and we'll need to adapt with the situation, either by phone, we do it all the time, or by video conferencing, Zoom, and whatever. Where I think is a very important issue is how to conduct witness examination and expert examination. Because what we're being told and what everyone says now is, like, to be efficient, don't use a lot of documents. So you need to change a bit the way you cross-examine. And so usually you may want to show 50 documents to the witness for 2 days cross-examination. Just cut it to 10%, choose the main documents and try to work on that. And that can actually work for some witnesses and experts, but not all of them. Again, I'm taking the example of a witness I cross-examined a long time ago. He had 100-page witness statement, a lot of allegation, relying on a lot of documents. And you know that part of the cross-examination is also sometimes educating the arbitral tribunal and going through the documents just to make sure that we can really go to the proper cross-examination point where you can really test the sayings of the witness. So I think that overall, and that's a strike, I think that this is the crucial point as to whether or not, and some hearings maybe have to be postponed in situations where there is a need for proper, lengthy, full cross-examination. And that technology may not allow it because after 5 hours or 6 hours and more than 15 documents, you've lost everyone. And it's hard to be focused on that. But again, I think these are the main issues. A lot can be overcome for some situations. I'm preparing witness statements right now, a cross-examination with smaller witnesses and less, and I think this is perfectly workable. And you can select often a very limited number of documents. But I think that's overall the general points I've seen and crucial challenges that we'll be confronted with.
Great, thanks, Benjamin. Olga, if I can turn to you. The theme of what Benjamin has been talking about is, I guess, in one way, is how reliable is witness evidence that as the tribunal sees over a video screen. What do you think? It is less reliable than witness evidence given in person, or there is no real difference?
To be honest, I think long term it is a matter of getting used to it. I don't think, if you're sitting, and this argument has been named in other webinars as well, in front of a huge screen, you would probably much better see mimic of a person, of a witness you're interrogating than even in the hearing room. You might also choose to have like full body view, so you see all the gestures. But at the end of the day, honestly speaking, if everyone thinks of our careers and experience, when you're analyzing a witness statement, when you're presenting as an advocate or are pointing to inconsistency, those are not gestures, those are inconsistencies in statements. I've hardly seen an arbitral award saying that witness was not, one didn't rely on a witness statement because of gestures. So I'm a bit more in favor saying that it's actually possible. So there are like, when it comes to documents or presenting evidence, like confronting with something physical, which happens also quite often as well, or maybe site visits, there are different aspects. But otherwise, as far as credibility is concerned, I am probably in favor of other parts of arguments, the other side.
Great, thank you. And Maria, question for you. So during my, not the hearing that I mentioned early on, but I had another hearing which included also obviously all the different screens. What I think makes it really different is that you can see both counsel for both parties, members of the tribunal and the witness all on the same screen, just like our images are right now. So you can observe the reactions of others when a witness is being cross-examined. Do you think seeing the reactions of all the different participants is a helpful tool during your witness cross-examination? Is this something that we're actually having an advantage as compared to witness cross-examination taking place in real life?
I think it depends. I can remember from my private practice, there are some arbitrators who didn't particularly engage into observing anything. I would take a step back and we probably sometimes would have to put it in the context of different legal cultures. The probative value of witness testimony will be different in certain common law jurisdictions and civil law jurisdictions. And as Olga was saying, in most cases that we see, and definitely that I have seen in Central and Eastern Europe, I've definitely not seen arbitrators only analyzing body language to assess whether the witness was credible or not. So in most cases, it's just irrelevant. In most cases, just what was written down will be more important than the gestures.
Great, thank you. I think let's do something a little bit different now. Let's do a scenario. So to set the scene, we've got an arbitration going on, and let's say in early February 2020, the parties in the tribunal agree to hold a hearing on liability on 20 May 2020, today, and they agree on the venue and the time frame, and then COVID-19 happens. The tribunal proposed to conduct the hearing virtually. The claimant agrees, the respondent opposes, saying that it does not agree and that the tribunal is bound by the February parties' agreement. So the question is the tribunal indeed bound by the February agreement, and how does the tribunal resolve this issue? So we're going to have Olga as the representative of the claimant. Benjamin is going to be representing. Maria is going to be the arbitrator in this particular issue. So I guess, Olga, what arguments will you make in favor of proceeding with the virtual hearing?
Well, for the sake of the exercise, but also in general, there is no virtual hearing at any cost. It is a balancing act between a duty of an arbitral tribunal to conduct efficient proceedings and to guarantee that all parties had the right to represent their positions. But I think that in this specific situation, this balancing act goes in favor of claimant. for the following reasons. So first of all, if you look at the agreement which has been achieved between the parties at the beginning of February 20, we must say that at the beginning of 2020, the COVID situation has not been yet that widespread and critical. It was rather contained in certain geographical areas. So it means with the spread of the COVID-19 in May 2020, on the 20th May of 2020, the parties are confronted with unforeseen circumstances which justify a decision of the arbitral tribunal to decide in favor of a hearing. So again, looking at the arbitration agreement, 20th of May can be fulfilled. The fact that the hearing is to be held can be fulfilled as well. The question is whether there is, physical presence required at that venue, or a virtual hearing would do as well. And Climate submits that because it's a liability argument, and in view of the specific facts of the case and of the requirement to decide this dispute efficiently in a time-efficient manner as well, the tribunal should move on. The parties will have the possibility to present their case. They will have the possibility to be heard. They will have the possibility to react to statements of the opposing counsel, witness statements, or consideration of the arbitral tribunal in real time, which is basically what is understood to be a hearing in arbitration proceedings and in front of state courts. Also, if one would think whether the arbitral tribunal has the power to grant an oral hearing despite the objection, the answer would be yes. We all know that arbitral tribunals are granted vast powers when it comes to conduction of the arbitration proceedings. Some procedural rules are speaking of in-person hearings, but again, in-person hearing might also mean an virtual in-person hearings. It can be guaranteed that all the parties and arbitral tribunal are present at the same time on a online platform. In addition, when it comes to the enforceability of an arbitral award, one should say as well that first of all, we would hardly find jurisdictions where virtual hearings are completely prohibited. And even so, in times of COVID, we have seen many state courts moving towards virtual hearings in these unprecedented circumstances. So the argument is made, can be made, that the state court is likely to interpret the contract and this situation in arbitration in the same manner. And finally, as we all know, justice delayed is justice denied. So again, balancing the interests of the parties in this specific case, the arbitral tribunal should order an online hearing.
Great. So we've heard the arguments in favor of holding the virtual hearing. Now let's hear from the Respondents' Council for the argument as to why the virtual hearing should not take place. Benjamin.
Thank you very much. I've heard all these explanations as to why a virtual hearing could be conducted or should be conducted in the current situation, and whether or not the decision from the arbitral tribunal to decide against the objection of the parties should have any impact on the enforceability. I think that's not the question at stake. The question is, there's an agreement of the parties, a clear agreement of the parties in February 2020 to hold the hearing in person. And that's the question is whether or not the arbitral tribunal could go against that decision. And to be clear, I fully disagree on the fact that this decision would have been taken at a time where parties were not in a position to assess the impact of the COVID-19. On the contrary, at the time, I think it was in January, 30 January 2020, World Health Organization stated that COVID-19 was a public health emergency of international concern. There were already lockouts in China. We all knew that the situation was worsening. And the reality is that because of the specific circumstances of this case, the parties chose that in February 2020, that the hearing should take place in person. And I fully agree with the position that arbitral tribunal have a margin of discretion to conduct proceedings in a manner that they want. They have discretionary power in this respect, but not against the decision of the parties, not against the agreement of the parties. And that's very clear from arbitral practice, case law, or even just arbitration rules. If you look, for instance, at the ICC rules, Article 22.2, paragraph 2, it stated that in order to ensure effective management, the arbitral tribunal, after consulting the parties, may adopt such procedural measures as it considers appropriate, provided that they are not contrary to any agreement of the parties. And you can find the same examples in ancestral rules and ICSID rules. If I take ICSID rules, it's stated, ancestral rules, Article 28, paragraph 3 of the 2010 rules, hearing shall be held in camera unless the parties agree otherwise. But actually, the parties have agreed otherwise in this case. And so it's not the position of the parties, the arbitral tribunal, to go against that. And if it does, then there's a real enforceability issue. And of course, the arbitral award could be set aside because of breach of mandate and other reasons for the arbitral tribunal taking a decision which goes outside the scope of its powers. So my position is that the arbitral tribunal is bound by the February agreement. And as a result, there is no other choice, absent an agreement of the parties, than to postpone that hearing, and no consideration of due process and others expeditious reasoning can be taken to go against the agreement of the parties. The arbitration is the thing of the parties. Parties can decide how to organize an arbitration. They've made a clear choice in February 2020 when they were aware of the situation. Going against that agreement would, of course, put the arbitral tribunal in a position where its award could be annulled and should not be enforced. Thank you.
Thank you very much. Now to very official looking in particularly when she wears the glasses, arbitrator in this case to make a determination. Should we have a virtual hearing or not?
Now, of course, to start with, of course, we don't have the exact terms of the February agreement. We don't know where's the seat. We don't know what the rules are. So we are a little bit in the dark here. But the first point that I would ask myself as the tribunal, and I mean, this case is something that I've seen a couple of times at the ICC, where we have the original agreement, and then one party withdraws from it. And that's what happens here. So claimant says, I withdraw from the February agreement. And so the tribunal will have to decide whether, because claimant no longer agrees, whether we still have the agreement or whether it has become moot. Because claimant says, under new circumstances, that's not what I want. And so I think that could be the first agreement, the first point to say that there is no agreement anymore because claimant doesn't agree to hearing in person and wants to have it online. In terms of right to be heard and balancing and due process, I think, again, you have to look at all the circumstances, but I think a tribunal will have to, in order to treat seriously respondents' arguments, the tribunal would expect respondent to give actual reasons why this would reach enforceability. So the first argument, I would say that there's an agreement of the parties that the hearing should be in person. I think it could not be valid if we assume that the agreement has become moot. And in terms of other objections that respondent hinted to, due process, for instance, as a tribunal, and that's based on my ICC experience, I would expect respondent to provide practical examples, because in and of itself, we have not seen, at least I've not seen any awards being set aside just based on the fact that the tribunal went online and not in person. So I think, as we said during today's webinar, there are many factors that will have to be assessed by the tribunal, but I think that in cases such as this, there are many situations in which the tribunal could indeed decide to go online with the hearing.
Excellent.
And of
Our
course,
hearing continues.
it's necessary to provide reasons for that, and the reasons should then be reflected very carefully in the draft, in the award.
Thank you, arbitrator. Well, we're getting close to the end of today's webinar. Some interesting comments from our audience. First of all, about body language. That seems to be an interesting topic. So a couple of things. One, different cultures, the same body language could mean opposite things. Something to think about when you reading it. And the question of whether perhaps, because I think some comments were made that not much attention is paid to things like body languages, whether in fact there should be training for counsel and arbitrators about body language. Olga, you're nodding your head. What do you think? Do you think a good idea?
I do think that in general, I mean, honestly speaking, right now, I'm like, sitting and shouting at my laptop. and it's just like at some point I realized it's difficult. It's completely different sense of owning the space and audience if you're talking, live to an audience. So I think also in terms of like how we behave ourselves, we are looking into the camera, or I would look at the pictures, then I wouldn't be looking into the camera, right? So there are these differences in, again, behavior and perception. So I don't think in terms of gestics, we've always been different, but I do think there might be some adaptations which would be required to transfer our arguments and our points in the best possible way in a digital environment.
Great. And Benjamin, a question for you from, do you think, have you seen force majeure arguments used to argue in favor of having an online hearing?
Force majeure argument to be online?
Yeah.
To favor an online?
Well, because you can't have it in person, so therefore, because of force majeure, and therefore you should proceed with an online hearing.
I think that's a very good example, because having worked, I think as many of us, we've all been asked questions on force majeure by our clients. I think that often force majeure is confused with hardship. The problem is always, it's very difficult, or it's more expensive, or it's not the initial deals, but the force majeure is impossibility. You cannot. There is no way out of it. And so I think that, and that may be something that we need to consider when there's arguments to be made, virtual hearing, is if the argument is that it's impossible, I think we should not take this for granted. And I think arbitral tribunals should investigate if actually there's not an alternative. Is it really impossible? The same way you would do if you receive a force majeure notification and you're just asking your counterpart, well, you're telling me it's not possible, but just prove that. I'm not just going to take that for granted. So, but of course, if the first case in France, where a French court said that COVID-19 was force majeure, was for a witness, well, not a witness, for a person in an asylum case, which couldn't go to court because he had been in contact with someone that had COVID-19. In this specific context, the court says, well, the fact that the person was not there to attend the hearing, that was Court of Appeal of Colmar, the fact that the person could not attend the hearing is a situation of force majeure because we did not have an alternative, such as a video conference, to allow him to participate. So you see in this very specific context, but again, it's always case specific. And I think that it's the role of the arbitral tribunal to ask questions and investigate that. And it's the role of the counsel to convince the arbitral tribunal that it needs to prove that.
Great, thank you. And then Maria, a question for you from one of our participants. How do you efficiently schedule an online hearing when you may have participants from all over the world and there's different time zones involved?
Well, I think we all can and have to get up early sometimes and go to bed late, and that's the solution. Just if you have to get up at 4 a.m., just go to bed early, late, early. Sorry, that's annoying. No, I think just have to adjust in good faith and just try to find a middle ground, and that has always been done because there are many conf calls that are conducted already like this, so it's not novelty.
Great, and then final question from me to all three of you, and then we'll start with Maria with you. Top tip for online hearings?
I would say the basic principles for the tribunal to create atmosphere of trust. And I think that with that atmosphere of trust and good communication, many possible guerrilla tactics in online hearings could be avoided.
Great. Benjamin, what's your top tip?
I think that Maria has mentioned a number of things that can be done in anticipation of the hearing to avoid disruption. I think there is a role and an obligation from the arbitral tribunal to investigate every issue as thoroughly as possible. But not only, it's also the obligation of the parties. And I'm saying the parties because I think, let's say, take the example of witnesses. If a witness cannot attend or cannot connect, it is for that party's witness to try to show the arbitral tribunal that it's done everything it could. Any alternatives have been investigated to ensure that that witness can actually not testify. And on the other hand, the other party has no interest of not helping the other party or assisting the arbitral tribunal because that party wants to proceed virtually. And there is a real concern that we all have of equality of harms, of due process. We know that the digital divide is a real issue which exists, but sometimes can be used as an excuse. So we need to investigate that. And so I remember a case where a party was saying we did not find any hearing center for a witness. And well, we did the work. We were the opposing side, but it's much more difficult for that party to say, oh, I didn't find anything. When the other party comes back and says, well, look, that's strange. I've just found another hearing center that is available. So I think it's an obligation for all parties, including the party that wants to proceed virtually, because it will want to ensure that there's no due process or equality of arms issue that can arise.
Thank you. And then Olga, what's your top tip?
I do think, it's the same as always. It's preparation. Preparation is key. And when it comes to technology, I would say testing. So what we've guys done yesterday, just dialing in and seeing how it's going to look like, which gives everyone the comfort that's how it's going to go. I think that might work also for arbitral tribunal parties and witnesses. So if someone has never experienced it before, I think it's possible to say, let's have a test run. Let's give a comfort to counsel and witnesses and party representatives that it might work.
Excellent. Well, all that remains is for me to thank all three of you for your excellent contributions. I've heard some really fascinating things and things for me to think about in preparation for online hearings. I hope our audience have also heard plenty of interesting and thought-provoking things. This has been a Ukrainian Arbitration Association webinar, first of hopefully many. So tune in, keep an eye on the UAA website for further webinars. Thank you to the speakers, and that's it for today. Bye-bye.
Thank you very much. Goodbye, everybody.
Thank you, bye.
Bye.